Depositions. If you've got a lawsuit, chances are you'll have to sit for one. Not to add to your stress, but your deposition can make or break your case. Don't worry. Today, I'm going to share the secrets that you can use to win your deposition. I'm also going to break down the one type of trick question that some lawyers use to trap you so you don't get it wrong. A deposition is a formal question and answer session where lawyers from both sides ask you about your case under oath. Think of it like a practice run for trial, but everything you say is on the record. Depositions are used to gather evidence, test witness credibility, and even push for a settlement before trial. The key players? You, your attorney, the opposing attorney, and a court reporter recording every word. In recent years, you're also likely to find a video camera in your face recording every twitch and every beat of sweat. Unlike in trial, where questions are asked in a specific order to tell the story to the judge or jury, your deposition questions might jump around, forwards or backwards in time, to keep you from anticipating what set of questions might be coming next. If you'll recall from our video on how to testify in court, you'll need to follow the same three-step formula. Listen to the question. Let them finish the entire question and make sure you've heard every word of the question. Understand the question. After they've finished the question, run it again in your head to make sure you are clear on what exactly is being asked of you. Don't guess what they mean. Answer the question. Don't volunteer more information than the question asks. Answer just the question being asked. Make sure that you actually answer the question being asked and don't try to dance around it. Don't waste your brain power trying to find a way to outsmart the attorney or to try to get cute. It doesn't look good in court and just drags the process out. If the answer is yes, then say yes. If the answer is no, then say no. If it's not exactly yes or no, then don't admit or deny something that isn't exactly true. I guarantee that you're going to be asked a question that you don't know the answer to. It might be something that you never knew, or it might be something that you just can't remember. There is a difference between not knowing something that you never knew and not being able to recall something that you once knew. If you can't recall something that you once knew, then don't say, "I don't know." Instead, say, "I can't seem to recall right now." This leaves open the possibility that you might be able to recall it in the future. Once you recall the answer to a question though, you need to make sure that you inform the other side and don't just hold it until trial. That's a fast way to get your evidence excluded. In depositions, specifically here in Texas, there are very limited objections available to the attorneys. There are just two that you need to be aware of: objection non-responsive and objection form. Objection non-responsive is what you should expect to hear from the attorney asking you questions if you start volunteering extraneous information or if you don't actually answer the question being asked. If you hear that objection, then you should expect that they will then ask you the same question again, so pay a little closer attention and remember step 3 to testify. Objection form is what you will likely hear from your own attorney who believes that the form of the question being asked is not permissible. The question might ask you to speculate, be a vague question, or it might be a compound question, meaning there's more than one question in that one question. If you hear your attorney assert objection form, just know it's like a bookmark for all of the possible objections that the judge will rule on later. You'll still answer the question to the best of your ability and to the best of your ability to understand what's being asked. In rare, very limited circumstances, your attorney may instruct you not to answer a question. This is where step 2 to testifying is so important, because that moment that you take to consider and understand the question being asked gives your attorney the opportunity to interject and instruct you not to answer. You'll only be instructed not to answer a question for things like abusive questions, preservation of privilege, or to comply with a court order. If your attorney instructs you not to answer, but you've already blurted out the answer, or you continue answering despite this instruction, then what are you even paying them for? While you're testifying, don't expect any help from your attorney. That's the reason that they have very few objections available, so that way you aren't tipped off on how to answer. One thing I've seen happen a few times is the witness asked their attorney how to answer a question, the answer of which wouldn't paint them in a very positive light. I had to remind the attorney not to assist, which of course made the witness mad and affected how they looked on camera. Some sneaky attorneys like to ask you whether you've ceased committing certain actions that you've denied ever doing. This is sneaky because there is no right answer. Here are some classic examples. Did you quit using drugs? When did you stop embezzling money? Have you stopped beating your wife? If you say yes, then you're suggesting that you had previously done this act and have now stopped. If you say no, then you're suggesting that you're still doing this conduct. If your attorney is paying attention, then they should instruct you not to answer such a question. If they don't instruct you not to answer that question, then you should refuse to answer. Your deposition might not be video recorded and might just be recorded by a court reporter with a stenograph machine. If that's the case, then definitely make sure that you are speaking slowly and clearly enough for them to accurately type down your answers. This is important since the judge will not be able to listen to your actual response in context if there's a disagreement over what your answer was. If your deposition is video recorded, then that recording can be played in front of the judge or jury at your final hearing. This is important for you to know because you want to dress for your deposition in the same way that you intend to dress for court. Don't show up to your deposition in a baseball cap, wearing a vulgar t-shirt, or looking generally unkempt. In fact, you should take a minute to review some of our other body language tips, as these are just as important in depositions as they are in court.